Good. Yeah. See, topic decoding role and commercial wisdom of CoC. Yes. Now, moving on to this concept of commercial wisdom, and more particularly, we need to understand the CoC, the format of CoC. What is the CoC? By now, you must be familiar what is CoC and what is the basic roles and responsibility. But we need to now try to understand, with the past more than 6 years, where the code has got implemented, and after it became force, and lot of CRPs and liquidation, and more particularly CRP was initiated by order of the Honorable NCLTs. So, and we used to follow the process as soon as the CRP order is passed by the NCLT, and there is a timeline given for each and everything. Of course, everyone who are in the practice, we must have followed it, and we have done it properly. Okay. Now, before going into commercial wisdom, because I'll a little focus on those aspects later part of my session. Before that, I thought I should take you through the legal provisions. What basically the legal provision, yeah, which is inculcated in the insolvency bankruptcy code, so that we can better understand, okay, what is the legal provision that governs the committee of creditors. Then after we'll go into a detail about the observations and orders of court. Probably the in detail orders of court, my next speaker friend will deliberate on that. But I will try to cover up a basic important judicial pronouncement, basic things only, not in depth, but more of I wanted to cover up the legal provisions and how now the commercial wisdom has evolved. That's the basic thing which I wanted to discuss in this session for next 2.5 years. Yeah, taking through this insolvency bankruptcy code. You all know insolvency and bankruptcy now almost settled, but still the law is evolving. And more of judicial pronouncement, the changes are getting introduced by way of an orders of NCLT, Honorable NCLAT, and Supreme Court. But basic things, the code, whatever the code carries, whatever the provisions, that's the basic thing that governs the entire roles and responsibility of the committee of creditors. So basically, the insolvency and bankruptcy code, you all know, it's a complete code. The code basically was to reduce the mounting of NPA in banks and to provide a easy exit for corporates, and also to ensure revival before liquidation. You all know that the object of the code is not liquidation. You all know Supreme Court very clearly observed that even the objective, the preamble of the code does not talk about liquidation. So that means the code went on to say that the IBC code 2016 is mainly to see that it is revived. The corporate debtor is revived, and the liquidation should be the last resort unless the company completely there's a loss of faith, hope in reviving the company, then the liquidation should be the last resort. That's what the court has observed in various matters. Now, the purpose of the deed of IBC, as you know, it's a unified code. It carries everything in one place. And it absolves this Presidency Town Insolvency Act and Provincial Insolvency Act and SICA, RDDBA and SAFASI and Companies Act. Of course, in that it subsumed only the Presidency and Provincial Insolvency Act and SICA. Remaining 3 acts are suitably modified. It's not subsumed by the insolvency code. This is the main purpose of the code. The code, do you have any inputs? Why it is enacted as a code? Because that has got a meaning. It has got an impact. So I think there are 26 participants are there. Okay. So I heard lots of voice.
Sir,
Yeah.
see, this is a code. Why they mentioned it as a code is that there are a series of steps which has to be followed.
Okay.
As compare, if you talk about act, it talks about so many other things, much more than that.
Okay.
This is a step. That is why it's called a code. That's my understanding, sir. That's all. Maybe I'm wrong.
Okay, then any other inputs? No, I purposefully I wanted to deliberate this because that only makes all the difference. See, though today we can deliberate about committee of creditors and commercial wisdom of commercial, of CoC members by the courts, but still the root, we need to understand what exactly the root and where it stems from. Okay, from then we can understand that how really the code is seen and the importance of code should be understood by us. So one of our friends shared his view. Is there any other views? And of course, he has shared one important thing. But is there any other view other than this? Why it should be the code? Why it should not be Insolvency and Bankruptcy Act? No, I have a reason for that to ask you.
Sir, consolidation of various enactments relating to the insolvency.
Well, it is
That is there. That is
codification
there.
of various acts, previous acts also.
Sorry.
Residency Towns Insolvency Act and Insolvency Act and IPP, IRDP or
Yeah.
Sikh Industrial
Yes,
Companies Act,
yes,
they all have been codified.
Yes.
This
So
is
that's
there.
the only purpose. That's the only purpose. See, that's the only purpose that the
To
code has
bring
been. Yeah.
Objective of the code is
See, you will appreciate. I'll come to you, the point.
resolve the
Yeah.
address the insolvency
Right
and resolve
from.
it.
Yeah, you finished, huh?
Yes.
Any point? Yeah. See, if you all remember, about 11 schedule got introduced in the code, right from section 240, 245 to 255, right? And what is the purpose of that schedule? Schedule 1 to schedule 11 of the IBC code, which start from section 245 to 255. What is the purpose of that? Now we need to understand why the government took an initiative to introduce this particular piece of law. Not I can say particular piece of law. It is a law that address entire financial failures of the corporate as individuals, LLP and firm in the country. So it's not a small piece of law. It's a code. That's why it's a code. Okay. Then why it has been introduced as a code? Because the purpose of code, calling it as a code, or purpose of introducing this as a code itself as convey that conveys the real intention of the government and how it should be seen, how the insolvency bankruptcy code should be seen. In fact, okay, I'll put the question this way. If this insolvency bankruptcy code is not enacted as a code, whether section 245 to 255 could be part of the act, Insolvency Act. If the code is not, if the INB code, Insolvency Bankruptcy Code 2016, if it is not introduced, enacted as a code, if it is enacted, assuming it is enacted as an act, okay, can there be a provision section 245 to 255 introducing the schedule? What is the schedule? Schedule is nothing but it is amending the acts. It is amending respective 11 enactments. That's why I'm putting this question to you.
Well, it is to enabling provisions.
More than enabling provision, my question was that I'm just trying to throw the importance of the insolvency code and what the government really mean, the code what it is. Okay, so why it is not enacted as an act, why it is enacted as a code? The main purpose is that enabling is different, but when it is enacted as a code, then only it can be a guiding principle and it can amend without any further legislative process of any other act. It can amend any other act without following the legislation process. That's the main intention of the code. You're getting my point? If it had been enacted as an Insolvency Bankruptcy Act 2016, then it cannot go on to amend other enactments without following the legislative process. To amend the other enactments to fall in tune with the Insolvency Bankruptcy Code. Only if it is enacted as a code, it can go on to amend other enactments which are inconsistent with the provisions of the Insolvency Bankruptcy Code. Okay, without following the legislative process of amending that respective law. That's what the 11 enactment, you all must be knowing that what are the 11 enactment it is amending. You must be knowing it, right? You want to remind it? No. Central Excise Act, Income Tax Act, Customs Act, RDDB, Finance Act, SARFASI, SICA, Payment and Settlement, Limited Liability Companies Act, Indian Partnership Act, right? And all these enactment as stood modified the moment the code is introduced and is given a force. Is it not? Are you with me? The moment code is introduced, the moment code is given force, okay, become effective. The whatever the amendment the code carries, the code consists of inculcated, whatever the provision inculcated in the code, it automatically amends the respective act which I read now, about 11 enactments. Correct? This can happen only if it is in a code. This cannot be made possible when it is enacted as an act, Insolvency Bankruptcy Act. It cannot be done because it is another act, like any other act, right? So if it is a code, this can have a power little more than an act. That's what we call it as a guiding force. This is not the single law. This is a complete code to address the financial failures of entire country with respect to the corporate and individuals on all commercial transactions. This is what, that's the reason this is enacted as a code. Okay, what are other codes in our country? Today, government is changing the name, but still, what are the other codes other than this? CRPC, CPC, and Insolvency Code. Is there any other code other than this? Other than these three codes, is there any other code in our country? In terms of law, in terms of legal provisions in any other code? There is no other code, right? Because there's a civil procedure code which completely governs, consolidates the entire civil matters and how the court should be dealt with the civil matters. Same way the criminal procedure code, it completely governs and completely guide the entire criminal courts, how the criminal matter should be dealt with. Same way now insolvency code, it completely governs the entire issues, financial failure, and also completely give guidance to the court which deals with the matter under Insolvency Bankruptcy Code, how the matter should be dealt with. Is it not? Hope you are all with me. So this is the purpose of introducing the Insolvency Bankruptcy Code 2016. So had it been introduced as an act, that cannot amend another act which is inconsistent to this act, then it has to undergo the legislative process again. So that respective amendment should be carried out. Say, for example, Section 178 of Income Tax Act got amended by virtue of introduction of the Insolvency Bankruptcy Code, wherein it done away with the requirement of intimating within 90 days about the due to the Income Tax Department. So that requirement was there earlier, previous, no, before introduction of the Insolvency Bankruptcy Code. Whenever a company goes into winding up liquidation, there's a requirement under section 178 of the Income Tax Act that the liquidator has to notify the amount to the income tax department, and he has to make sure once the income tax department confirms the amount, the liquidator should make sure, ensure that amount is allocated. Means that amount is kept away for the purpose of department. Otherwise, the law went on to say that the liquidator personally liable. Please go through the language of section 178 of Income Tax Act. So it went on to say that if the liquidator fails to allocate the money, whatever the claim of the income tax department, okay, and if he fails to allocate that money, then the liquidator will personally be liable for the amount which is due to the, that was the original provision before the introduction of the Insolvency Bankruptcy Code. So then the IBC went on to amend, because the IBC is a supreme law and it's a code. And it says the IBC, every act, every enactment should be subject to the provisions of Insolvency Bankruptcy Code as long as it is inconsistent with the Insolvency Bankruptcy Code. This is the basic fundamentals of the Insolvency Bankruptcy Code, why it has been enacted as Insolvency Bankruptcy Code. That before we move forward, we need to understand this particular thing. Then only we can appreciate why this concept of debtor in possession has become creditor in possession. Earlier, Insolvency Bankruptcy Code, the whole thing was debtor in possession, the concept. Okay, in every other countries, you can see the insolvency and bankruptcy law. It was a debtor in possession concept. Okay, now slowly they understood that debtor in concept doesn't work well. So let it be a creditor in possession, so that they are the stakeholder and they are the people who supposed to deserve to get the money, whatever the realization that is accruing out of the process, in the insolvency process, bankruptcy process. So that's the basic fundamental whereby the Insolvency Bankruptcy Code has been introduced by the government. So if you see, when it got introduced, you all know that 21st December originally 2015, then referred to the parliamentary committee, then report came, then court passed by the Lok Sabha 5th May, then Rajya Sabha 11th May, then consent by May 28th. Then when it is notified, but it is notified from 1st December 2016. Any idea why after code became effective May 28th, but notified only in 1st December 2016? Any idea why it is got delayed? Why after introduction of the code? You must be knowing that maybe we would not have become an IP, but of course we may be in practice, so we must be knowing the reason why it is introduced much later than after its notification came. The notification came May 28th, but the law became effective from 1st December 2016.
Sir, there were many other, things are pending, like BFR matters pending. So many things have to be done aligned with the new code. So many acts also.
Yeah, one way you are right. Yeah. One way you are right. The other thing, reason is that that time only NCLT was ready to take up the matter of IBC, because IBC, if you see NCLT was adjudicating authority for the IBC. Okay, under the Insolvency Bankruptcy Code, NCLT is the adjudicating authority. So the constitution of NCLT has become complete and to deal with the Insolvency Bankruptcy Code. So that's why it is introduced from 1st December, because we were not having an adjudicating authority ready by that time when May 28, 2016, when the IBC code got introduced. Okay. So this is why I am giving this prelude, because this is the basic thing with which we have to understand what's the real ideology behind this Insolvency Bankruptcy Code, and why the court went on to say, giving more importance to the Insolvency Bankruptcy Code rather any other enactment, though there are few contrary judgments are there, but still court many times they upheld the supremacy of the insolvency of bankruptcy court. You all know in many matters the Supreme Court has upheld section 238 is a complete one, and which supersedes and overrides every enactment as stated in the section 238 of insolvency bankruptcy code. So that's the background of it, where the court wanted really to give more weightage and importance to the code. Okay. Now, if you see what exactly the IBC code 2016, it's a new method to seek resolution of company. Okay. Then what is the real difference? Earlier, there was you all must have been handling winding up earlier, where the court used to appoint the liquidator. Means the court, the High Court, the liquidator, office of liquidator, which is attached to the High Court, used to act as a liquidator for any company which is under winding up, which is undergoing winding up and liquidation. But now government thought that why professionals should not be involved. Rather, it is handled by court. Why not the professionals should be involved? Is it right or wrong? Now, after seeing 6 years journey, 7 years journey, friends who are there as a participant, can you share whether government what they thought, is it working well? Now it came from the hands of the government to independent professional, right? Handling of insolvency, bankruptcy.
Sir,
Is
you're
it
talking about a voluntary liquidation or CRP?
everything, entire thing I'm saying.
Sir, it's working well, but only thing is IBP is becoming acting as an inspector.
That's
Too
okay.
much of controls, sir. Poor IP, no support from the management, no support from the government, no support from NCLT. So he is becoming a sandwich. Very voluntary liquidations are working very well because the company is there, money is there, support. CRP is like this. When there is some accident, they'll send it to the body for an ICU. They're no taker. Hospital people, when security is there, sir, doctor is not there. So I think more support is required and more to the IP. As you know, in your experience, I think you also appreciate IPs. Forget about their fees. Even they have to spend their own personal money to ensure the compliances. One penalty, one delay is there, IPP comes with a heavily and a penalty. Yes, sir.
So what can be the way out, or what can be the solution for this?
I think that the government has to do something, and they should not even recently even had High Court order also see the passed an order against IBPI saying that you have to moderate and you cannot pass for small issues and suspending membership, those things. So High Court is also realized he is an judiciary, but IBPI has to change their attitude, and some support is required for an poor IP, I would say, who comes for this IBC. And many of the people, many of the senior people, nobody, very senior people, they will not take AFA. They will become only advisory role.
Okay. So in this scenario, what do you all personally feel about giving a commercial wisdom to the CoC members? We will discuss on the legal provision. That's apart. I'm just taking your inputs on that.
Yes, sir.
Giving more commercial wisdom to CoC. Is it working well, or is it working in reverse?
I think I'm not handled. Maybe I think others can share.
Yeah, it's okay. I think others also must be having experience, similar experience. No, why I'm asking this point, of course, we'll understand the legal provision, but still, how it works, last more than 6-7 years, we are practicing the IBC code, how it works. And if we share our experience and views only, things can change. If we keep quiet, things will remain. And everything, if things will go on, that's all. So government also will feel, okay, everything is okay, all right. The professionals are so happy with the practice of RP, liquidator, okay. They are so happy. So there no more changes is required. We will give more and more commercial wisdom to CoC. Is it so? Can we give more and more commercial wisdom to CoC? Friends, you please open your mouth and talk. I can simply go through the sections and go. That's not a big deal for me. You all know the sections. I also know the section regulations. I can simply show you, explain, and I can move on. That you want me to do, I will do that and go. Or you share your views. So that accordingly I can articulate, moderate my section. So
Yes.
we can give more and more commercial wisdom. Supreme Court has deliberated. There is no doubt. We are not going to deliberate, discuss anything on that because very clearly in SR Steel versus Satish Kumar, Supreme Court has made it very clear. It's the commercial wisdom of the CoC to decide as to whether or not to rehabilitate the CD by accepting a particular resolution plan. All that is discussed by Supreme Court in detail.
Sir, I have a doubt, sir.
Yeah.
Maybe I sound very cynical,
Hmm.
but in case of CoC, which consists predominantly of financial creditors,
Okay.
all my experience is that they are more interested in treating as a recovery process rather than rehabilitating the company.
You're
So,
right.
so when you talk about I mean, I'm just coming to the fundamental. I mean, it's not a conflict between
Yeah,
them.
no. You have every right to share your views.
No. I'm just saying, is it not a conflict between their recovery, their ideas to recover their money vis-a-vis the rehabilitating the company? So that is where
But
I find it no.
what we can understand by commercial wisdom, please that's a right point that you have given for deliberation, actually speaking. Friends, I have 80 slides. Okay, that's not a big deal. I can run the slides and go. I can run the no. See,
Correct. You're right. Absolutely.
there are about 30 friends who are sitting here. Please don't play hide and seek game. Okay? Whatever you want to come out, you come out. There's nothing wrong because after all, we are all practicing. This is a forum where we have to deliberate. And
Right.
I don't think, except this forum, we have better forum to deliberate. If you keep numb, then we have to practice as it is and move on only. And we have to read the law and follow the law and enjoy the practice. Okay. So rightly, a friend has pointed out this, that one way the CoC wanted their money back. They are very particular in that they wanted their money back. That means number of times the court has pronounced, okay, judgments and order has been passed by court that don't use the IBC as a recovery, don't use IBC as a recovery mechanism. But my friend now who has deliberated, he very categorically saying, to some extent I also agree, and many of you may agree also, that the CoC, few CoC, they are very particular on recovery only. They want their money back. Whether is it not going contrary? That's what the question of our friend. You have any other inputs on this to add? You have nothing to add, or do you have anything to add? Please share your views. Is it not going contrary? One way we are talking about commercial wisdom. The other way, there is understanding that CoC wanted their money back. Their money back, not others, stakeholders, okay? Their money back. Is it going in tandem or it's going contrary or opposite to each other? It's just a deliberation we'll have. Then we'll go to the provisions of the code. There's nothing to offer.
No, but point is when you say commercial itself means you have to take care of yourself. To take care of oneself.
Then
Put it that way.
Then the same court says that don't use IBC as a recovery mechanism. What? Your answer itself gives this question.
No, that's what I'm saying. The point is their attitude is like that. And when you say commercial wisdom means, the commercial wisdom is I'm here to, I'm a banker. I have to lend money. I have to correct my money with interest.
So court themselves confer the right to the CoC, be commercial, okay?
Agreed.
Be commercial, and also our respected honorable courts insist all stakeholders, RPs, IBB, everyone, that don't disturb the commercial wisdom of CoC, correct?
Agreed.
Agreed. So that when the court itself, the highest authority, the Supreme Court, Honorable Supreme Court, they themselves wanted to give commercial wisdom to the CoC to decide whether to agree something or not. And not even they are talking about wisdom. They are talking about commercial wisdom. That means you leave them free. Whenever they feel they are benefited, they are getting profited or benefited out of it, they'll take a call, they will inform you, they'll decide. Then just follow it. Is it the output or this outcome that we need to understand? Means CoC is given a commercial wisdom. Let them decide whatever they want to decide. Commercially, however they benefit themselves, let them take a decision. Commercially, however they get a more benefit, and don't disturb, don't interfere with that decision. Even the lower courts also don't interfere. So no, I just want to understand exactly how to the whole thing we need to comprehend. Both the side it's going contrary, you know. So if we comprehend properly, we can follow the same, right? So
Right. You're right. You're right. I'm not able to comprehend that. Apologies for my ignorance.
our friends are they will only fight with the department. They will not share their views. Individually, they will fight and they will see that they are managing the show. Or they will individually convince CoC that okay, whatever you instruct, as long as it is acceptable, we will do. Otherwise, anyway, we are going to question only. But still, what is given, the weapon given in the hands of CoC? I'm not going to ask you right or wrong. Is it working well, or it is working really to the benefit of all the stakeholders, or really to the benefit of the intention and object of the code? This only I'm asking you.
You see, based on the past 6 years experience, say from 6 or 7 years experience, and what RBI has said was, because there have been a substantive decrease in NPAs of a lot of commercial banks, of the institutions. So this must be working, but I don't know what. But my thing is that commercial wisdom means I have to take care. One has to take care of oneself. That's it. Period. Whether that person has wisdom or not, I don't know. But the knowledge is available. Wisdom is something which is which comes from inside. Doesn't come from outside. Knowledge is available outside, but wisdom has to come from inside.
Okay, I'll put it this way. See, I agree, I understand, I completely respect the orders and judgments of honorable courts. They wanted to give commercial wisdom to CoC, and they can decide. And of course, we can understand the roles and responsibility. In fact, you are not here to decide whether right or wrong. Okay, we are here to understand what is the roles and responsibility, and what the court has given a judicial pronouncement on commercial wisdom of CoC. Okay, good. So my point here, if a commercial wisdom is given CoC, whether the CoC, of course, there are provision is inculcated, introduced in the IBC code that CoC also should make sure the OC is getting compensated properly. All that is there. But in many of the cases which I could come across from our friends and other media sharing all that, many of the cases where CoC is not accepting the resolution plan, and CoC wanted good numbers for accepting the resolution plan. Or probably we would say that CoC putting some conditions which they wanted the resolution applicant to accept, or CoC rejects the plan. Okay. Here, one important thing, CoC is given a commercial wisdom, no doubt, because they are the beneficiary. The idea of the court, why the judgments are coming this way, because the idea is that I started a session saying that data in possession to creditor in possession. Idea is that giving in the hands of the creditor, no doubt, giving in the hands of the creditor. So creditor is nothing but who is stand in the first CoC members, financial creditors, no doubt on that. So the court feels that when they are the custodian in charge, in fact, one of the judgments it went on to say, the court went on to say that CoC should ensure to achieve the object of the code through RP. Through RP. That's the language used in the judgments. Through RP. That means this RP is only an interface. So RP is not given a responsibility of what is to see what is right and wrong. He has to see that what are the instructions flowing that's followed. Is it so? RP has to listen, or RP has to simply follow. Of course, there are rights. I'll show you the complete table, probably a little later of the session. What are the roles of the RPs and what are the roles of CoC? Where we need to take of approval of CoC, where we need RP can on his own, the RP can carry out things. All that the table, in fact, IBBA itself gave out with a clear, complete table. I can share you that. I can show you that, and we will discuss that also. But before that, all this is just understanding sake only I'm asking. So that we can, after this session, we can better understand. See, if you want me to deliberate the provisions of the code, I can deliberate, or even you want to deliberate the orders, what passed by the court, I can deliberate. We can move on. But I don't think that is the only real idea of having a session, because now and then we are getting shared all judgments and everybody reads. And now and then the amendment comes getting shared that everybody reads. I don't think speakers like me has to educate you to know the provisions and all, or to know any orders and all. Of course, we can give our views on that. But everything you all know, because today we are living in an era where that those days have gone, where after a week, after a month only, we get information to know when something is introduced, something got notified. Today, in a matter of hour, we get to know. So our idea here is not to say what is the law governing to CoC, what is the orders governing to CoC. That all you must have already would have come across. You must be better knowing than me and anybody else. Okay. All we should know is that really, are we going in a right path, or do we need any diversion or any change, so that we can suggest to the institution, we can see that all these things are really escalated, so that accordingly things will move on. Okay. Today, do we have any code of conduct for CoC? Today we have anything? Any idea? IBBA is introduced some time back, right? Is it binding, CoC? Sorry? Is it crosstalk, or you want to answer? Anything is there? Any code of conduct is there? But RP has got code of conduct, right? IP has got code of conduct.
Yes.
So CoC doesn't have. But there is a provision in the IBC code that I will show you. There's a provision in the IBC code that the IBBA means the IBBA will introduce an code for CoC. There's a provision specifically there in the IBC code. Okay. But still, we are not able to introduce a code. Why? Commercially, wisdom is given by court. We are not disputing anything on that. We are not having a different view on that. Is that court say that you don't come out with any code of contact to the CoC? Then what is the say? Okay, the court has given a complete commercial wisdom because see, it is the commercial wisdom of the majority of the creditors to determine through negotiation with the prospective RA as to how and in what manner the CRP is to take place. All that feasibility, viability, all that is there. What is the guideline given to them to decide? Is there any guideline? Is there any guideline given to them? How it is to be decided? Fine. Evaluation matrices are there and there are provisions introduced in the code. Correct. And how it has to be followed, in what manner it has to be followed, in what timeline it has to be followed. Is there any provision in the CoC? Means any provision in the code or any orders for CoC? Court has come out with any orders, any prescription, how the CoC has to do and in what time it has to do. In fact, yeah.
I don't think so. I don't know.
See, one of the matters, case Asidhar versus IOB. There, they very clearly, the court categorically said, the court grants paramount status to the commercial wisdom of CoC without any judicial intervention. Okay, so judicial itself, they should not be, the intervention should not be there. The judicial intervention itself should not be there. So correct, good, well and good, because they are the owner or of the entire thing. Okay, what are the liquidating estate, what we call. We may deem it as the CoC are the owners of the liquidation estate because they are the beneficiary for the proceedings or realization of the liquidation estate. No doubt. But how far it is right, completely leaving in the hands of the CoC, the commercial wisdom, I think we need to wait and see how it is going to. But of course, there are few judgments, I don't deny. Even Rajputna Properties Private Limited, this is Ultratech. The court very clearly says CoC should have transparency while accepting rejecting the plans. But they said you should be transparent, no doubt. But still, there is no guideline. There is no complete clarity on as to how the CoC to deal with in a particular situation. See, I have my own experience. It's not that simply I am putting this because there are 5 CoC members, 2 CoC members will not agree because, as you said, they wanted their own thing, and we can go by majority. There is no doubt at all. But again, there will be one person who will be off-minded. Neither he will fall this side nor that side. Okay, so entire thing again fall back to the original position. Just because of the decision making. That's what the IBBA also came out with a notification. You all must be knowing, right? The notification, the IBBA, wherein it clearly said, I think 10th August 2018 notification. It clearly said that IRP directed that he shall in every notice of CoC, any communication addressed to, they should require that may be represented in the CoC or any meeting of CoC by such person who is competent, authorized to take decision on the spot without deferring the decision. At least can you tell me after the circular, after we are quoting the circular, we are sending the notice, quoting the circular, all that. After the circular, whether CoC is represented, banks representing through appropriate person who is taking decision on spot, at least can you open your view on that? Can you open out and can you open up and talk? Yeah.
My view is, I would be very categorical. I don't think so. I don't want to elaborate, but I don't think so. That's what I'll stop it at that.
Okay, then okay. So is it not in contrary to the, it is not going in violation? If IP violates, it is in violation to the code. If CoC doesn't follow, it is not so. Can we deem it that way? No, I'm just asking.
I'm
No,
scared. I'm scared to open my mouth, sir.
there are
I'm scared.
so many learned friends are there, but what to do? They can't share everything, it seems, here. They have a lot of things in their heart, but they can't share. But I don't understand. Then there's a specific circular, okay, which says that you mentioned the notice, and it is getting mentioned also in the notice. It is getting shared also. And I have my own experience. After this provision came into effect, I myself sent notice. CoC, as you said, it didn't happen that way. He categorically said, no, I'll go back and I'll send my comment. In fact, one of the things, court itself has ordered that you take a decision. But there also CoC members said, no, I'll go and tell. We are not competent to decide this. We have to go to the head office and come back. So they came back after a long time. By the time the purpose itself got defeated. Okay. So I think so you all presuming means you all maintaining silence. That means you are agreeing all of the views which are deliberated here.
Yes, sir. It is true. What you said is absolutely true. I agree with you wholeheartedly.
That's
But
what.
some things cannot be opened out. You cannot open your mouth,
That's what, see, I presume my dear friends who are keeping quiet, they are agreeing all these views. So unless they come out with the different views, because if they come out with different views, it's welcoming one. Because I wanted to know really in a different dimension of this particular understanding. If there's a different dimension, we will understand that. Okay, we'll try to understand. We try to follow also. If it's not, then we have to deem it that whatever we are deliberating here, our friends also is accepting it. Okay, good. I think, yeah. So now, okay, enough. I think now we can't help it, right? We can conclude this way. We will try to understand the provision and move on, because anyway we are not ready to deliberate or ready to have a different view. We are not ready to have a different view on that. So we can better deliberate the law and move on. Okay. So even this one of the matters, Shaji Purushothaman, I believe, Union of India, it very clearly says CoC is required to decide whether the proposal given for settlement in terms of 12A is better than resolution plan or not. So every option is given to CoC. Okay. And one more Sriram e-technology also, they gave CoC to look at the viability, feasibility, other condition of the resolution plan in respect of the corporator and the CRP. So that means the entire thing is given in the hands of CoC, actually speaking. Only thing is they have to be regulated, or probably there should be some guiding principle that should come, whereby the clarity should emerge how the CoC has to be dealt with, how the CoC members has to be dealt with. Because though law says that you conduct a meeting, you share minutes, or you give entire information, transparency, everything you give, but still, unless
I have a suggestion to make.
yeah, please.
See, point is, as far as insolvency profession is concerned, okay, IBBA is more competent to regulate. But as far as this institution is concerned, don't you think this RBI is more competent? It should, don't you think that RBI should come out with certain kind of norms so that these cases will follow? See, for IBBA, for them, they are not the regulators, right? You may call them a thing and all, you may call them a regulator for the, say, IBC and all that. But for institution, it's RBI who is more competent. So if you want any kind of, if you want to enforce any code of conduct or something, don't you think it should come through an RBI circular or something like that? That'd be more effective, isn't it? Correct me if I'm wrong.
Can I say something jovially, not on record? Okay.
Go on, I'm listening.
Will you put your own terms and regulation that I will behave like this, I will do like this, I will do.
No, I cannot put it because I have to obey the IPBA.
No. I'm asking you as an individual. Can I take your name?
Madhu.
Madhu, yes. Mr. Madhu, what I'm asking you, I'm not talking as to a RP or IP now. I'm talking to Madhu.
Yeah.
Madhu, can you put your own rule saying that Madhu, after waking morning, wake up, after you wake up, you should not drink tea. After you do, you should not talk wrong to the people. After you go outside, you should do good only.
Agreed. What you said is right. What you said is right. That is what I mean. My mom has trained me for. She has trained me from childhood. We have like that.
See, your mom has done, but generally people don't prefer to regulate themselves. Okay.
No. I'm just saying.
Here also you said mom only said. Okay.
No, because my mom used to tell me, my mother, she used to say, get up at 6 o'clock, have this, have that, like that. So you have attuned to that behavior.
We don't get that tendency to put our own this thing to regulate. Correct? We don't get that.
Right. That's what I'm saying. That's what I'm saying. But for
that
the
means RBI has to be instructed.
no, not instructor. They should also come out they should collaborate and they should come out with certain kind of norms so that it is more effective. That's what I'm trying to say. Rather than IBBI coming out and these people, they are not. They say their main thing is their main bosses are RBI. For all the banks, their main bosses are RBI. Period. You want any banker? Let's see if there's an RBI circular to this. Let's see if that's RBI. I mean, I'm not making fun of them. That is the mindset. That is what I'm saying. In case if it has to go through it, what I'm saying is let RBI also collaborate with the IBBI and come out with such kind of norms so that it will be more effective. That is exactly what I'm trying to tell you. See, why I used the word mom is, see, initially when we were born, all of us were regulated by the parents, especially by the mother. Same way for banks also, their main bosses, the boss who breathes down their neck is only the RBI. So that is what I'm saying. If the RBI comes, it will have more effect and it will be much more effective. That is my take.
I fully agree. What I was trying to say, RBI has to come out, no doubt. RBI is not why they are not coming out only. I'm putting this way why they are not coming out. They may be thinking why to regulate ourselves. We have to come out with some regulation. Okay, you understand what I'm saying?
No, I got you. But in this case, since it's an NPM, usually when it comes to IBC, it's generally these assets are LPA. So as a matter of facilitating the revival, they could come out with such kind of norms as by way of some kind of master circular.
If your employee works well and get more revenue to the firm, will you appreciate him or will you criticize him?
I'll definitely appreciate him.
Then why you want to bring out a rule, regulating your employee when he is already getting a more profit? They are getting more profit. Why they have to regulate themselves?
That's what I'm saying. No. You and me, we are all commercial people. Agreed. But RBI, IBBA, or government as well cannot be commercial. They have to be public. They have to be socially minded.
Then what you call? See, what you call it GST, you call income tax, all are revenue to the government. No, otherwise you need not to collect it at all. It's not
agreed. Yeah, but
question of commercial.
I agree, sir. NPA is a drag to the society, sir. NPA is a drag to the society. If you are able to revive it, see, they have come out with so many master circulars about sick unit monitoring, sick unit revival, blah, blah, blah. They can also come out with some kind of a regulation kind of for the handling the CoC. That is what I'm saying. It's a suggestion. It is only a suggestion.
Okay, only one this thing, one of the judgment I remember, orders I remember in Supraj Carspin Mills, I remember. That's the only thing the court has said, the CoC has to comply with the provisions of the code. That is the only thing I remember. One of the judgment came in Subraj Carspin Mills.
No, because but if another regulator is also there, then it has it especially if RBI is there, it has weight. Or whatever you say, even government also listens to so many governments listens to RBI. So definitely see once they come out with some kind of master circular about the conduct code of conduct for the CoC, it will bind on them. They cannot wag their tail anymore.
In fact, that whatever IBBA circular, what I showed in the screen, that's not the only thing where the CoC got mandate. In fact, one of the matter SPJ Exports, I believe, SPJ Exports Manufacturing Private Limited, where the court has very clearly said members of CoC should give the authority to their nominated representative for smooth voting process. They very clearly ordered. That's what, see, though, the problem is that there are so many mandates are given, but still, anyway, let's not drift away the topic.
I think
Let's try to understand the commercial wisdom.
Right.
What is the commercial wisdom given to the CoC? We will try to follow that. We will understand the law and we will try to follow it.
Right.
Good. So now coming back to the thing, we all know that objective of achieving value maximization, and all this is a principle of so these and all can be a collective action which can be organized. It can be ensured through CoC. Okay. So here, if you see the code, coming to the provisions of the code, okay, where the section 18, it only where it starts the duty of IRP, where section 18C it says interim resolution profession shall perform among many duties, one of the duties to constitute the committee of creditors. Okay, so here IRP is given responsibility to constitute the committee of creditors. Okay, then again the IRP shall, after collation of all claims received against the corporate debtor and determination of financial position of corporate debtor, constitute. So it's become a responsibility of the IRP to constitute the committee of creditors and see that because once they collect the claim only, he can properly arrive at who is financial creditor and who is operational creditor and what. So all this idea will emerge only when he collect the claims. Okay. Now coming to section 21, if you see one important thing, who shall be the committee of creditor? Okay. Here very clearly it said that so the committee of creditors shall comprise all financial creditors of the corporate debtor. But here, what the exception is given that provided one financial creditor. Yeah.
Hello.
Yeah. Hello. Hello. Who is this? Any doubt? Okay. So this is the parameter which this is another proviso which has been put in section 21(2), where that shall not apply to the financial sector regulated by financial sector regulator. Okay. If it is a related party of the corporate debtor solely on account of conversion of debt, all this, there are provisions which we all know that. So here, again, if another provision on committee of creditors, okay, where the corporate debtor owes financial debts to two or more financial creditor, then each financial creditor shall forming part of the CoC. So this is another important clarity that we should get, that everybody should be part of the committee of creditor. Okay. Now another scenario. Okay, subsection 4 throws another scenario where any person is a financial creditor as well as operation creditor. Such person shall be a financial creditor to the extent of debt owed. So the remaining he'll be deemed as a operation creditor. That's what the whole understanding goes. Okay. Then again, another scenario, if you see, when an OC has assigned or legally transferred any OD to a financial creditor, the assignee or transfer shall be considered as OC to the extent of such assignment. That means just because of you transferred your your debt, the color cannot be simply changed from one hand to another hand. Okay, so it is seen as from which hand it's coming. If it is coming from the hands of operational creditor, then that particular debt will be deemed as a operation debt. Again, it talks about subsection 6. If you see, talks about financial debts and consortium arrangement and whatever, what is the thing can be provided. They can authorize a trustee agent to act on behalf of the committee of creditors, then represent in the committee of creditors and appoint a IP. All this is a terms of the financial debt which can be extended as part of the consortium. Okay. Where a financial debt in the form of security deposit and the terms of financial debt provides for appointment of trustee agent or so if it is owned by a class of creditor exceeding the number, then IRP shall make an application to AA along with a list of all financial creditors containing the name of IP, and of course this process is being followed by us, whenever there is class of creditors. Okay, this other prerogative wherein it's represented by a guardian, executor, administrator, such person shall act as a authorized administrative. Then if you see 6B, it talks very clearly that the remuneration payable to the authorized representative and the whatever will be discussed shall be as per the financial debt and shall be as specified as part of the insolvency resolution process cost. So board as usual has given a power to specify. Now, all decision of the committee of the data shall be taken by vote not less than 51% of voting shall be. Here it is very important that every decision of the financial creditor, other than what is specifically stated as 66%, other than that, every decision should be 51% voting power. Okay. Suppose the CD does not have a FC, then CoC shall be constituted and comprise of such person, excess of that we will see in the coming up slides. Now, CoC shall have right to require the RP to furnish the financial information. That right they have during the CRP process. Of course, now the law got amended, the code got amended to the level, even the valuation report has to be shared, during the liquidation process. The RP shall make available any financial information so required by the committee of creditors within 7 days of such a request. So these and all has to be. In fact, here one important thing that I have to highlight, section 21 makes it clear under subsection 10, RP is given an obligation that RP shall make available any financial information so required by CoC within a period of 7 days of such acquisition. Then if you RP is not supplying the information or document within 7 days of acquisition, then it goes on violation. Is it the similar thing is there that when RP writes to CoC and CoC has to respond within any timeline or any communicate the decision within any certain time limit or communicate only in this certain fashion, nothing is there. But there's a clear mandate on part of the RP that if CoC asks, RP has to give. If RP asks, there is no provision when to CoC give. Even whether to give or not itself is not there. Is it obligatory on part of CoC that they have to follow whatever RP says? My dear friends, please, you share your inputs. Without having idea only, I'm asking this. Don't think what I'm asking, I'm knowing and I'm asking. Is there any provision in the code whereby the CoC has to follow or at least consider and cooperate to RP? Extend cooperation will say, except liquidation cost. Liquidation cost, there's a provision. Now, anyway, the regulation came into force. Okay, liquidation cost, okay, we need not to discuss about liquidation cost. Liquidation cost, there's a separate provision whereby it clearly says the CoC shall make sure if there is no enough liquidity, the CoC's funds, that is there. Other than that, any other provision? Can you share any other provision if you have any idea of it? That CoC has to support, extend whatever RP or liquidate, or of course liquidation, CoC is not there, only the stakeholder committee under regulation 31A is there. Is there any provision under code or regulation where CoC has properly respond or cooperate? Or the RP has to resort to section 19 only to get a cooperation? Can I have your inputs? I'm not the master, you are not the students. I'm also one among you who is practicing. If you are struggling, I am also struggling. If you are enjoying, I am also enjoying the practice. Okay. So let's have a clarity, what exactly the code conveys or what exactly the code carries the provisions. Is there any provision that are we have to resort section 19? No answer. No idea. And during CRP, it's only section 19 only is the only recourse. We want to make CoC to listen. CoC has got commercial wisdom, no doubt. We are not going to deny that. CoC has got commercial wisdom. They can decide. Yes. Yeah, please. See, if we have to get a proper attention of CoC, do you have to resort section 19 only in case of CRP, regulation 9 in case of liquidation? Of course, regulation 9 not for this thing CoC. Generally, there's in case of non-cooperation. So I'm just that's my basic doubt. So that's the only provision that we are, or they are duty bound for that. We are giving a complete free hand with respect to commercial wisdom to CoC. Because RP is nothing but he is a person who has to carry out his function based on the instruction of CoC. So that means it is one way. It's not two way. The instruction only will come. Can't be other way around. Can we understand that way? My God.
Yeah, that is what it is. That is what is happening. You only have to obey the CoC. Okay, so long it is illegal, it's fine. You have to obey the. You cannot give instructions to CoC. You have to take the instructions from CoC, and of course act within the parameters of IBC.
But if you see one of the matter, or Venkata Krishnan versus Paragon Steel Private Limited, the court said that clearly CoC should support RP and the research applicant by way of making all documents available to them. That is very restricted one. That one, not that.
I agree, because it in the code itself says that everybody shall cooperate with the RP to furnish the documents, necessary documents. I agree on that particular point. But when you're running the say RP, you have to obey the CoC. Period.
So, but here, if you see with respect to the RP, it is as a clear mandate whereby RP shall make available any financial information required within 7 days. Here, the timeline is very important. If RP is not going to supply within 7 days, then RP into a violation. RP
Has not obeyed the CoC.
has not obeyed and he has violated the provisions. Okay?
Exactly.
That only I wanted to.
Yes.
So now coming to the appointment of reservation, as you know that first meeting of committee of creditors will be within 7 days of the committee. The committee of creditors in the meeting by majority not less than 66%. Either to resolve or appoint IRP or the RP or to replace the IRP with another RP. This is a routine provision where CoC resolves under subsection 2. Okay. To continue the IRP as RP, subject to written consent, all that it introduced subsequently, it shall communicate its decision to IRP and the corporate data and AA. Or if they want to replace IRP, it shall file application before AA for appointment of proposed RP. So now you understand, now the power of removing or throwing out RP is given in the hands of CoC. Then now you can expect give any advice to CoC. If you give any advice, CoC will throw you out. If they don't like it, not every CoC, but few CoCs, those who are not liking you with your advice, they will throw out. Okay. if they are not getting maximum benefit with your advice. Is it so?
That is a practical situation. That's a practical scenario.
So now they are, now of course, now it has even extended to now liquidation also. Now liquidation also, the liquidator can be removed, of course, by adjudicating authority, but here, it is given in the hands of CoC itself. Okay. So now if you see from the whatever provision which we have gone through, section 21, 22, what now we have gone through. So this we can finally understand what the IRP can be appointed as a RP. Okay. Then CoC can replace the IRP by another RP. Okay. This is another thing. The third one, the CoC can replace RP if it is of opinion that RP appointed is required to be replaced. It may replace him in the manner specified under section 27. So these are the positions that emerge out of the sections what we have seen. The adjudicating authority also empowered to replace the RP in case of resolution plan submitted 13 is rejected for failure to meet the requirement. This is a power given to Honorable NCLT. Then the RP appointed under section 33 shall act as a liquidator. Again, the same thing only. If it is continued, he will be continued. That's all about the appointment power of the responsibility of the CoC with respect to the appointment of RP. Okay. Now coming to the meeting of committee of creditors. So in meeting of committee of creditors, if you see the meeting of committee of creditors, the members of the CoC may meet in person or by such electronic. So they are given an option to meet even electronic means also. So all the meeting of CoC shall be conducted by RP, and RP shall give meeting notice of each meeting to members committee of creditors and including authorized representative who are appointed under CR 21 and members of suspended board of directors, then operation data, the representative over. Okay. Now the directors partners representative of OC, they may attend the meeting of the committee of creditors but shall not have a right to in such meeting, provided that the absence of such director representative as it shall not invalidate the proceeding. So that will not invalidate, but they will not have a right to vote. This is the position actually. Now, if you see that who is a member of the committee may appoint an IP also. That we all know that they can appoint an IP also to represent themselves. Okay. Of course, the fees has to be borne by them individually. Okay. So whatever they vote, that we know that voting percentage, so voting sharing, or as per the vote sharing, they will be based on the financial debt. Okay. RP shall determine the voting shall to be assigned to each creditor based on the claim whatever received and based on the amount of whatever is frozen. Okay. The CoC shall be conducted. Of course, there is a regulation in place which will be seen. Okay. Now coming to the approval of committee of creditors. Now, if you see the RP during the CRP, he cannot take any decision, following action, not even this thing. He cannot take any of the action without prior approval of CoC. What is that? Raising any interim finance in excess of the amount as may be decided by CoC. Okay, if CoC says, why you want this much money to run? No, you run with this money. They have to obey by that. Is it so?
Yes. Unless you give an overwhelming reason, even then they have the power to restrict your spending.
One of the matter I heard one of my friends said where he wanted to run at least 50 lakhs to run the to run the factory with
Maintain the plant.
or whatever security guard or whatever it is, but CoC was not willing. They were simply saying no, we'll approve 8 lakhs.
But then tribunal cannot interfere, sir.
Is that the commercial wisdom is to reduce money expenses also?
The commercial wisdom also says don't throw good money after bad money. That is also commercial wisdom, no? That is what they say. Why should I throw good money after bad money? That's exactly what they are saying.
So you don't want to revive the company and run.
No, not that way. As I told in the beginning, The idea is that these guys are more on the recovery mode rather than the revival mode. I'm being blunt, sir. This is what is happening on the ground. I'm being blunt between you and me. Okay, it may be recorded, but this is my view. If they say 8 lakhs, means yes, you have to live in that within the day. We have to live within that budget, because they are funding the expenses. So they have the right to say that. Suppose the bank is weak. I'm just saying, just hypothetically, I'm just saying. Say, suppose we have been in year 2022, and then you are dealing with one Yes Bank or Punjab, that bank which went under and then it got merged. That bank didn't have money. Now what you'll do? You can't just, even they also have a fund constraint, isn't it? I mean, I don't know. I'm talking for the bank, but this is the ground situation.
Like our any other friends, we'll also accept all these facts and we'll move on. Okay. Sure.
Okay.
Both
Right.
are sounding okay. Other friends are enjoying our sounds. Okay. So
Thank you.
let's also remain silent and let us understand the law and we'll follow the law. Okay. Raise any interim finance as okay, as may be decided by the CoC in the meeting. Okay. If CoC says you run, though you need 50 lakhs, you run with 5 lakhs, RP has to make sure that he is doing it properly. Okay. He cannot go and object. He don't have power to do anything beyond that. Okay. Create any security interest over assets of the corporate debtor. Then change of capital structure of the CD, including by way of issuance of additional security, creating class of security, buyback, all that. Okay. So what are this thing? Then again record any changes in ownership interest. These are the things where, see, these are the important things. If you see the approval where they deem it interim finance raising, security interest, all are capital item. It's not a revenue item. All are capital item. We have to be carefully, we have to understand here. Record any change in the ownership interest. Okay, give instruction to the financial institution maintaining accounts for debit transaction and undertake any RBT transaction, means related party transaction, and amount any constitution documents of the corporate debtor. So all are very important thing. And delegates its authority to any other person. What is this delegating authority? Is that delegating authority to RP or delegating authority to any other person or one of the members of the CoC? How we can understand this? Any idea?
Can I come again? Come again, the question, sir?
Delegate its authority to any other person. Under section 28, it says one of the, see, where we are seeing the approval of committee of certain actions. Okay. So these are things which need approval of committee of directors. So in that, one of the point is that delegate its authority to any other person. Delegate its authority to any other person. Section 28.
Okay.
So that means to whom? To any person it can delegate. It includes RP or any person outside.
Can give it. It includes RP also. Yes, anybody.
Anybody, or whether it is among the CoC or outside CoC.
Usually it's given to the lead bank.
That's what. See, probably the consortium bank is authorized dedicating the authority to lead bank, the lower bank, the consortium bankers. The lead bank giving authority to consortium bank, or consortium bankers giving authority to lead bank that on behalf of us, the lead bank can take any decision.
Exactly.
This should be understood that way, right?
It will be understood that way only. Yes, sir.
It says very openly any other person. That means
It can also be their advocates. It can be their counsels. It can be their representative, like what?
no, sir, please understand. My dear friends, all you please listen and understand. My concern is different. Because now our friend CoC friends have not understood exactly what is there written. They have not have properly gone through. Then if they understand this, suppose I'm saying, presuming I am a CoC member, another CoC member, I delegate my authority to any other person only, it says. Can I give this authority to my council to see that you decide this particular thing, how to do? My firm, legal firm, or my any other advisory firm, can I delegate to? Because it is not restricting. It is simply says delegate its authority to any other person. So if tomorrow CoC says, or one of the CoC member, okay, CoC says, of course I agree. The entire CoC has to accept, it has to approve. By means of resolution, it has to approve. I'm not denying it. Because it says prayer approval. So with the prayer approval, that's what I was putting this question to you. With the prayer approval, whether CoC can delegate its authority to outside person, I'm asking.
I'm sorry to interrupt here.
Yeah.
See, section 28(1) starts with the words,
Hmm.
the resolution professional during CARP shall not take any of the following actions
Hmm.
without the prior approval of CoC.
Correct.
And one among the H point is delegate its authority. So
Correct.
is it the resolution professional delegating its
No,
authority? See,
no,
for the
that's what I'm
CoC to
asking. No, I
yeah, no,
understand.
I understood your point. I mean, very valid. Whether
Correct.
delegating to a lead bank in a consortium or otherwise, or to a
Mm.
third party, which you were just discussing. So
Correct.
for that, for each of these, let's say, members of the committee of creditors, being the consortium, for them to delegate their power to one of the lead bankers,
Correct.
they
Yes.
don't need to involve the RP at all, right? When a matter
Correct.
comes up for voting, they can have an inter-se arrangement between them, saying that you
Yeah.
vote for all of us.
Agreed. To
Yeah,
any other
so
person, it is very open. That's why I'm asking.
yeah, so my worry is the resolution professional during CRP shall not delegate its authority to any person
Both
without the prior
RP
approval
or
of CoC.
whoever it is. Yes.
Yes, so it may include the RP delegating his authority
Yeah,
also
I am putting
to
it together
anyone.
only. Both I'm putting
Yeah,
together. Yes.
yeah. Okay,
It's a decision, combined decision of RP and CoC
right.
involving an outside person. That only I'm asking.
Yeah,
No,
okay.
RP cannot delegate any of his function to anybody.
But it says no with
It says,
approval.
but see, the point is, RP has to discharge his duties and his functions. Whereas CoC's wisdom, commercial wisdom, and all that, they feel like voting for some plans and all that, or assessing the some plans which they have received from some RA. Those things can be, they can delegate it to either one specialized firm, or they can give it to the lead bank. That is the spirit of it. That is what I'm saying. The RP cannot delegate his duties to anybody.
See here, after reading this particular line, delegate its authority to any other person. Its authority, it says its authority. That itself.
It says its authority is the CoC has its authorities over RP, but it does not have superintend. He can only superintend the RP's work. But RP still has to do his works. RP's function is only subordinate, not part of the CoC. That's what I'm trying to tell you.
Agreed, but this particular thing literally goes into task
A
for
tangent, it goes as a tangent. Correct.
Yes. Yeah,
Absolutely.
especially given the
completely.
fact that you can't even outsource your responsibility.
Yes. Okay. I wanted to bring it out certain few things here. That's why.
No, it's absolutely well said. Well said. This is only now you pointed out, only then I understood. Right.
Yeah, yeah.
Okay. So now
And quite interesting, in fact. Yeah.
Fantastic. Absolutely. Well said. Well said.
because it's a code, it's not a regulation, it's a code actually. Okay. So now coming to next point, dispose of or permit the disposal of shares of any shareholder of course, this we can agree what make any changes in the management of corporate debtor and its subsidiary. So make any changes in the management of corporate debtor. Anyway, if they want to put, anyway, directors are suspended. So if you want to change any management this thing, and with the approval of CoC, we can do. That's what we have to understand. Transfer rights are financial debts and operational debts under material contract. So all this, we need material transaction means as I was earlier telling you, all not revenue item, capital item, all related to thing, not a minor thing, it's a major thing they are talking about. Make changes in the appointment and terms of conduct of such personnel as specified by the committee of creditors. Make changes in the appointment or terms of conduct of such professional personnel as specified by. Here also, if yeah, if that means the RP is given a role of or obligation of keeping the corporate data going concern. Okay. Suppose the CoC doesn't approve any changes in appointment, whether whoever CoC suggests with that person, with that personal, only the RP should make sure the CD is run. The CD is in running condition, or CD is taken care of affairs of the corporate data, because it says with the approval of CoC only, the changes in appointment or terms of conduct of such person shall be made. So that means, I think somebody who is talking.
Hello.
Yeah, hello.
I want to ask one question.
Yeah, please.
Suppose the study auditor has resigned from the company.
Just a moment. How could suddenly from 32 it became 37? What is the real number actually? Why it is fluctuating like a like a stock exchange, numbers are going up, going down.
Hello.
Yeah, tell me.
Hello.
Yeah, tell me.
Statutory auditor has resigned from the company, and his appointment is to be done. Then the approval of the under the section 139 of the Companies Act, the approval of the EC is required. Whether the CoC can appoint to that auditor in that case?
No, you are telling auditor during CRP. You are telling.
During the CRP has resigned from the firm, and another person is to be appointed. The power of the appointment vests with the shareholder, and the EC meeting is required in that case. So
CoC meeting.
The CoC, EC, Executive Committee meeting is required for the appointment of the statutory auditor under the Companies Act.
Okay.
So in that sense,
when
the CRP, during the CRP, my question is that during the CRP, whether the CoC can appoint to that, yeah, RP can appoint,
during
the EC will appoint.
No. During CARP,
the auditor has resigned from the company, and the statutory auditor is to be appointed for the audit of the company. So who will have the power to appoint the statutory auditor? Whether the RP can appoint, or the CoC will appoint, or the shareholder will appoint under the Companies Act?
First of all, who will sign and give the financial statement to the auditor? Who will sign the financial statement of the? Who will sign the financial statement for audit?
Will be signed by the statutory auditor as well as by the director in that place.
No, when it is
RP has come, the RP will sign.
Director is suspended, no?
Who suspended director?
You will be suspended.
The director is only suspended. His only his powers are suspended. His duty is not suspended.
Question is that who will appoint the statutory auditor?
RP and CoC.
See, anything during CRP, CoC only will decide.
There is no provision in the IVC that the RP will, CoC and RP will appoint the statutory auditor.
Now you see the next point, sir. You see next point.
Because of that, my question is that
hold on.
I want to say,
Hold on.
Companies Act provision will not be abolished after the CRP has started. Every provision of the Companies Act will have to be followed. Only those provisions which is especially mentioned in the IVC, that can be done by the RP, and every compliance is to be done by the RP. If the statutory auditor is to be appointed, will be appointed by the company under the Companies Act, not under the IVC. So my point is that whether the CoC can appoint in that in this mess, Or the RP will appoint, or we have to go to the shareholder for the appointment of the statutory auditor.
You finished, sir? You finished? Your question is over.
My question is over now.
Yeah. See, I was trying to say that only. You can see the next point. I was reading L. Now you please see the point M. It says make changes in the appointment or terms of contract of statutory auditors, internal auditors of the corporate debtor. So this also need approval of CoC. And the RP has to do.
It means that so far as my understanding is concerned, it means that if you have appointed to somebody as a professional, matlab statutory auditor, then you can, if you want to change some in the appointment, like the fee or other thing, that can be done by the CoC. But the purely appointment is to be done, matlab new auditor is introduced for the appointment, then the shareholder approval will be required as per the Companies Act.
Please understand, once company comes into CRP, once company come into CRP, it is only the RP and CoC who can decide. Though we can say that duties of powers and the directors are suspended, powers are not suspended, all that we are talking, but still they are kept away. The directors are kept away. Okay.
But the power of the statutory auditor based with the shareholders, not with the directors or any.
That's what I'm saying. That's what I'm saying. It's kept away. Now, once the company comes into CRP, it is only purely the CoC and the RP who has to take any decision with respect to their corporate debtor. Please understand, there is a provision, overriding provision in the IBC.
So under this provision, that appointment can be done by the CoC.
Same provision, what section 28, I was reading that only.
It doesn't say that CoC has the power to appoint the statutory auditor.
Yeah, it says
They say
CoC can only give approval for appointment of term of contract.
Where it is mentioned the CoC has the power to appoint a new auditor.
Now see the slide, see the slide, M, point number M.
Make changes in the appointment, not the new appointment is to be done by the CoC.
Okay, then who will sign the accounts and who will conduct the meeting, who will every question comes on the company side. In fact, after 6-7 years, still there is no link between the Companies Act and IBC. Still there is no link. Who will run the company? Who will send notice? Who will take responsibility? No, you wait, hold on. If suppose the RP signs with the blessing of CoC, RP sign the financial statement. Okay, if you are going to say that we will make the suspended director to sign, the suspended director will not sign. He will say, no, I am suspended. Why I have to sign? I'm not going to sign. In which case, what he will do? What RP will do? Suppose the RP sign with the directions of CoC.
Yeah, RP will sign.
And who will?
The question is that
Hold on, sir.
auditor has resigned from the company.
Hold on, sir.
The new statutory auditor is to be appointed.
No, hold on, sir. Hold on, please. If RP sign, in case of any violation in the financial statement, who is responsible for that violation? Who will go for compounding, or who will get on to the prosecution provision under Companies Act? There are so many hundreds of questions are coming in. Okay, we can't only pinpoint the word uses is changes only, not original appointment. There are so many hundreds of situations will arise in the CRP where there is no answer, because there is no link between the Companies Act and IBC even now. Even now, once the CRP is admitted, the company is admitted into CRP, and once the RP comes into place, the board suspended. Even now, everybody is facing a challenge. Okay, we'll break for 5 minutes, 10 minutes. Okay, there's a distance. We'll break for 5-10 minutes. Okay.
Before you go, hello, Dhanapal.
TM फाइन हो गया, TM फाइन हो गया. हाँ.
Pradeep ji, can you mute yourself?
UK side. हैं? नहीं डर जैसा तो अब नहीं लग रहा है ना? डर जैसा तो नहीं लग रहा है, मगर क्योंकि ध्यान कंट्रोल चीजें होती है तो डर थोड़ा बहुत जब तक रजिस्ट्री ना हो जाए रहता ही है। अब पेमेंट पूरा हो गया, एसेट 10 लाख, एसेट 10 लाख सब पेमेंट चला गया। हाँ सर। हाँ नहीं, कल लग गया था। हाँ हाँ, तो आज आप वहाँ जाएंगे? जाएंगे?
Hello, is the meeting over?
No, it's a break, 10 minutes break.
It's a small
Okay.
break. Yeah.
Yeah, yeah. Thank you. Thank you.
बोल दीदी कंप्यूटर कंप्यूटर
Yeah. Shall we start again? No, I'll share my
Yes, please.
screen.
Yeah, yeah.
Yes, before proceeding further on this, I wanted to take you through an important this thing, because after this, for want of time, we should not miss this. This is one important table. Okay, I think this completely throws the entire this thing, which this is part of the circular of IBBA 1st March 2019. This is issued in aid of the IP and the CoC, and this kind of a some clarity is IBBA has attempted to bring some clarity on that. Okay, this in that they given a clear charter. Okay, what are the roles and responsibility of IRP and CoC. And this is very nice actually, because they try to cover entire. Okay. Good. Now, I think before proceeding our slide, I thought I can, that this is looking very good. So I thought, okay, let me focus little on this, then to take you through. Yeah. We'll try to understand now the responsibility of CoC, IRP and RP and CoC in a CARP. This is what we are deliberating today to understand what is the roles and responsibility and commercial wisdom. Of course, this is the part of the thing, what are the process that we need to follow as a responsibility of IRP, RP, and what are the responsibility assigned to the CoC, means that can be inferred that as a CoC has got these are the things as responsibility. But IBB came out with a nice table whereby they made it very clearly the responsibility. In fact, in this green, red, and 3 colors are there. You have to understand what is that. The green is responsibility, means wherever it is color green is coming, it is the responsibility of that, whether RP, IRP or a CoC. If it is green, then blue is nothing but with the approval of CoC, what are the authority given to IRP and RP? This is a blue, and the red is there's no role. There's no role of CoC or RP in that particular item. I think this is very nice to understand. So what are the, and we can even cover up the steps. What are the steps involved and where the responsibility of RP lies and where the responsibility of the CoC lies in a CRP proceeding. Okay. Now coming to the public announcement, as you all know that the IRP should make a public announcement within 3 days of appointment of calling of Section 13 and Regulation 6. Of course, all these provisions we all must be knowing, but we will go by the event. That's very important than the regulation. Anyway, I can share this. This is very much available in the website also. You can literally go through the regulations on this. So making public announcement within 3 days, it's a responsibility of the RP. Okay, all this green, all this is responsibility of RP. Management of affairs of the CD, exercise powers of board of directors. See, here powers of board of directors. Okay, so all that with the RP. Then compliance with the requirements of any law on the CD. With the RP, it's a responsibility of RP. Collect information, it's a responsibility of RP. Receive, collate, verify, claim, it's a responsibility of RP. Ascertaining the class of creditors, identifying and selecting authorized representative, applying to AA for appointment of AR, provide list of creditors, all that is responsibility. Then comes RP, all this is responsibility of RP. The first one is IRP and RP. Okay, here CoC has got no role. Okay. Now constitution of CoC and filing of report with the adjudicating authority, so RP, and holding first meeting within 7 days of filing of report under regulation 17, it is with the RP. And carrying an as RP from 40th day till RP is appointed, responsibility of IRP and RP, filing of information and utility, information utility, then monitoring assets of CD, manage, offer, take control, custody. All this is the responsibility of the RP. Make application to AA in case of non-cooperation from CD, promoters, any other person. Whether the any other person include CoC members, we should. That's what I raise this point. So CD, promoters, or any other person required to assist, cooperate the IRP and protect, preserve value of property, CD, manage operations as a going concern. These are responsibility of RP. Appoint accountant, legal, and other professional as may be required. Here in appointment of professional, one important provision I want to show you. If you go to the regulation, CRP regulation, regulation 27, I think it talks about appointment of professional. Except this, there is no other provision in the CRP with regard to appointment of professional. Okay, so better to understand what is the code provides for appointment of professional. Okay, so if you see here the appointment of professional, yeah. See, the RP shall within 7 days of his appointment, not less than 45 days, 47th day of enforcement commitment, appoint. All this is there. If you come, this is appointing of the RV, the issue valuer. Coming to next this thing that the IRP RP subsections 2, as the case may be, may appoint any professional in addition to the register valuer to assist him in discharge of his duties and contact of IRP if he is of the opinion the service of such a professional are required. Such service was not available with the corporate debtor. So in that case, this is a very important thing that the IRP and RP should make sure that the IRP RP shall appoint a professional under an arm's length basis with the following object and transparency, provided that following person shall not be appointed. Who shall not be appointed? Relative of a resolution profession should not be appointed. A related party of the corporate debtor should not be appointed. An auditor of the corporate debtor at any time during the preceding 5 years preceding the insolvency commencement date should not be appointed. A partner or director of the insolvency IPE, of which RP is a partner or director, should not be allowed. Okay. So the invoice fees or whatever expenses of the professional appointed under this regulation shall be raised in the name of profession, be actually paid into the account. So this is the only provision which is there under the CRP regulation on appointment of professionals. So before getting into appointing any professional, this is the important point that we need to. So this is a responsibility of the RP IRP. Okay. So enter into contract on behalf of CD to amend contract and commencement, RP CRP. IRP and RP. Rise interim finance within the limit set by CoC. This only we were deliberating a little while, just earlier. Issue instruction to personnel of CD for keeping it as going concern. This is again a responsibility of RP and IRP. Make financial information available to CoC within 7 days under section 21(9). We have seen just some time back. So this is a responsibility of RP IRP. Very importantly, the confirmation of IRP as RP or replacement with IRP. This is the responsibility and roles of CoC. This is not because this is appointment of IRP and RP. Okay. Then again, providing all information document records pertaining to CD to RP. And before that, to file any application with the AA for replacement, this is again a responsibility of CoC. This is not. So this is again important thing that we need to understand. This is the responsibility of CoC, filing an application with the AA and providing all information also to CD. So again, he has to make right RP or IRP should write to the company and take detail from the respective person. Filing of withdrawal application before AA. This is another important thing. This is the responsibility of both RP and CoC. That only I was showing below the blue color, which the IBBA has stated. Blue is authority of IRP, RP with the approval of CoC. So here what we have seen is a responsibility of both RP and CoC. Okay. Ratifying expenses of IRP. Again, if you see here, this is a responsibility of CoC, Committee of Creditor. It's a role and responsibility of Committee of Creditor. Disclosure of insolvency process, of course, RP, IRP should do. Preservation of record, it's responsibility of RP, IRP. Again, conduct of CRP in compliance with procedure of code and regulation is again RP, CRP. Management of affairs, exercise the powers of Board of Directors, CD and RP, IRP. Compliance with the requirement of any law on behalf of CD is RP, IRP. Modifying percentage of voting rate requiring quorum. This is very important. See, modifying percentage of voting rights required for quorum. This is a responsibility of CoC. The voting percentage is 51%. This is very important to understand. Okay. Now again, attend meeting of the CoC, including participation today, video conferencing, again IRP, RP. Convene meeting of CoC wherever required on request by the member, 33%. Voting right, IRP, RP. Reduction of notice period for holding meeting. Reduction of notice period for holding CoC. See here, this is the responsibility of CoC. Okay, I'll show the provision which talks about notice period and reduction of it. And preserve and protect the assets of the CD, including the continuing, again RP, IRP. Take control and custody of assets of CD, RP, IRP. Represent and act on behalf of CD with third party, exercise the power. Then again RP, IRP. To approval to raise if interim finance. Again, we have seen this list of items which can be carried out only by approval. Okay. Approval by CoC. This is a responsibility of both RP and CoC members. Then again, to appoint accountant, legal professional, then RP, we have seen above also. RP and IRP. Maintain updated list, RP, IRP. Preparation of circulation of IM to CoC. This is again RP, IRP. Providing information bearing resolution plan upon request from member of CoC. Then RP, IRP should make sure he is providing it. And obtaining confidential undertaking from CoC and RA. Then responsibility of RP, IRP. Publishing invitation of EOI from prospective RA, RP, IRP. Then specifying the criteria of a prospective RA. This is the responsibility of CoC. It is voting percentages 51 again here. Then due diligence of expression of interest received to assess the compliance with the criteria specified, including seeking the clarification, additional information. Again, this is RP, IRP. Then issue provisional list of eligible prospective RA, then RP, IRP. Issue final list of eligible IP, IRP. Then issue of IM, EM and RFRP, all that is the responsibility of RP. Details of parameter. What are the parameter to issue EM and interest, RFRP? All this has to be decided by both RP in consultation with the CoC and within the parameter as provided and approved by the CoC. The approval percentage is 51% here. This is very important to note here. Details of parameter of EM and RFRP 51%. Then the extend timeline for submission of resolution plan. Again, this is the timeline which we need to understand is that the responsibility of both RP and CoC. Of course, with the 51% voting rights, the CoC has to approve the extent of timeline. Then again, reissue of RP, again 51% of CoC approval is required for inviting the interest. Okay. The present all resolution plan which fulfill all criteria are there. CoC, then it is RP responsibility. File application for avoidance transaction, responsibility of RP. Replacement of, again, we have read it already, we have seen it already. This is the responsibility of of CoC with the 66%. This is the important we have to understand. Here we have seen all 51%. This is 66%. Then again, creation of security interest over asset of CD. And this is both responsibility of RP and CoC. This is again 66%. Approval is required from CoC. The change of capital structure, what we have seen already, discussed already. This is a responsibility of both RP. With the instruction of CoC, the RP has to do. This is again 66%. Record any change in the ownership of interest of CD. This is again 66%. The RP, with the instruction of CoC, both they have to take responsibility. Payment limits from bank. This is important thing. All are required approval of CoC to RP. What is the approval voting percentage? It's a 66%. So payment limits from bank. Undertake any related party transaction. So again, there's a 66% approval is required. Amend any constitutional document. Again, 66% approval from CoC to RP. As we were discussing this, delegating the power. Then dispose or permit disposal of shares. Yeah, this is again need of the approval. Make any changes in the management. Again, 66%. Transfer rights and financial debts.
Hello.
Yeah.
Hello.
Hello, tell me.
Hello.
Tell me, sir.
I want to know if 66% of the voting is required. So it is a person who will be present in the voting, then 66% is required. Out of that 66% is required, yeah, total voting percentage 66% is required for the approval.
No, see, if you see, I will show you this particular thing. Okay. I'll show you this particular provision.
Okay.
This only we were discussing actually. Okay. Yeah. See here. No action under subsection 1 shall be approved by committee of Gada unless approved by a vote of 66% of voting shares.
A voting share.
Yes.
So suppose that the home buyer is there, 2000 home buyer is there, the voting, they never attend to the voting, right? So it is not possible that you will get a 66% approval of them. In that situation, what the
No, it says voting shares. It says voting shares. So that means it has to be, it has to go by voting shares only.
It has to go by
voting shares only.
Need the voting share.
See,
voting
wait.
share in the
You
total
read,
voting
no?
share.
Let's read here. It has a definition. What is voting share? Okay. It's a share of voting rights of a single financial creditor in the committee, which is based on the proportion of financial debt owed to such financial in relation to debt owed by corporate debtor. So now this is a definition. Voting share is based on that. Here, what section 28 talks is based on voting shares. Okay. So it's supposed to be, because we can't simply neglect people. So it has to satisfy 66% of voting shares.
They are saying the voting share of the financial creditor, not of the home buyer's share.
Voting, whoever got voting in this CoC, that shares only they are referring.
66% of the approval by the voting share.
Voting
My
shares.
question is that in the case of the home buyers, 2000 voter is there. And 66%
Proportionate will be added in that. So proportionately it will be added.
So no, such amount of the shareholder never attend the meeting. Only the 20, 50, 60, 80.
No, they will be represented, home buyer will be represented by authorized representative.
So in that case, how the resolution will be passed?
He is represented by authorized representative, no? That's
Eh?
and also he is represented by authorized representative, right?
I could not
That also
understand.
I
I could
showed.
not follow. I could not understand.
For
My
class of
question-
financial creditors, the voting will be done by the authorized representative,
Yes.
not by the individual financial,
Yes.
individual home buyers.
That only I was saying.
No, individual home buyers will give the voting to the insolvency well, AR, na?
So they are correct.
Yes. You're right.
But the
Yeah,
financial
based
creditor
on
is not.
majority will cast the vote.
Eh? So it means the person who will present and vote, their share will be counted, na?
See, you see the provision here.
The
The
provision
authorized
is there,
representative.
but we have to understand the subject on that basis.
No,
See,
no,
what
no.
is the meaning
Yeah,
of
here
this
you
document?
see the rights of the authorized
Suppose
representative.
that 2000, my specific question is that 2000 shareholders is there, only 20% is attending the meeting and they will cast the vote.
No,
Suppose that they have
66%
casted the
is
vote
based on.
in favor of the resolution and more than 60%, 66% people has casted their vote. In that situation, the vote resolution will be treated to be a pass or will not be treated to be a pass because only 20% has given the vote out of 2000 voting share.
No, so while first is number is irrelevant, it is only the percentage that is relevant. Second thing is assuming that what you're stating is about the percentage of shares or percentage voting share. If so many people have abstained from voting or have not turned up and voted, then the resolution cannot be passed.
Cannot be passed.
Yes.
So 2000 voter is there.
You are not allowing me to show the provisions at
My
all.
again question is that suppose 2000 person may 100% voting share is involved, है ना? Or only 20% is coming. Only the suppose karo that 10% of people are attending the meeting and they are casting their vote. But the person who has attended the meeting, they have given the more than 66% vote in favor of the resolution. Whether this resolution will be treated as a pass or not.
You are asking about your case or you are generally asking, sir?
I am generally asking this question.
Generally asking. So can I read the provision? Can you allow me to read the provision first?
Yes.
Because you are presenting your point, but when you read only you will understand. See, the authorized representative under section 6A of section 21 shall cast a vote on behalf of all financial creditors he represents in accordance with the decision taken by a vote more than 50% of the voting shares of financial creditor he represents.
Yes, my question is that. Bilkul sahi, you are saying right. Matlab he represents who have cast their vote. This is an important that who have cast their vote.
So what? No, there 51% is required. Order. There 51% is
who
required.
have casted their vote.
Yes, sir. You read this. This gives a clarity actually. This gives a clarity.
Very simple. In case of class of creditors or home buyers, AR has to take the voting from the class of creditors whom he represents. Going by the majority of who have voted, he will take a decision whether to vote in favor of the resolution or against the resolution.
He cannot take the decision. He have to vote according to the voting given by the home creditors in a class.
Majority
decision.
who have voted.
Sir, what I showed you read. What I showed 3A, have you read? You understand? No, sir, please, you understand my question. Have you read the 3A?
Yes.
Please read it, no? Please read it once. For me, please read it, no? Just read it. No, please read it. 3A, you please read it. Please read it. I want to read.
I'm reading.
Please, no, loudly if you read, I will also follow.
Notwithstanding anything to the contrary contended in subsection 3, the authorized representative under subsection 6A of section 21 can cast his vote on behalf of all the financial creditors he represents in accordance with the decision taken by a vote of more than 50% of the voting share of the financial creditors he represents.
That's all.
Who have cast their vote
That's
This is
all.
an important who have cast their vote. But the
Correct.
person who are present in the voting, at the time of voting, they have casted their vote more than 50%, then he will give the voting by the AR, according to that. Not by the whole of the community of the vote.
Here it says the representative who cast their vote means whoever casting, whoever is representing, it refers.
Whoever
He represents.
whoever represents. तो वही क्वेश्चन है कि वहां पर इतने सारे लोग होते आते ही नहीं है ना वोट करने. प्रॉब्लम इज दैट.
I don't understand Hindi what you're telling.
So Pradeep ji, I think the answer is simple. So first step is the AR taking the vote of the class of creditors whom he is representing. Okay, in that if more than 50% of the people who have voted what they have voted, whether it's a yes or no, that is his fine.
उसको जरा ये समझने की कोशिश करें 50% कौन से लोग जो वोट कर रहे हैं वो या टोटल.
हाँ जी, those who have cast their vote, that means those who have voted, that is for this, for the AR, not for the main thing.
Yes.
Then the AR will cast the vote on behalf of the creditors he is representing in the CoC meeting for the resolution.
Means is that the person who have voted at the time of the meeting, if they cross to the 50% in favor of the resolution, then he will cast the vote on behalf of all the.
No, he will first take. AR first will take the voting from the his own financial creditor. Then he will attend the meeting.
Yes. Okay.
Okay. Now that's why I wanted to read, because we have to, every word is important in that. Every word is important. Okay. So now coming to this. Yeah. Modifying. Yeah. So submission of resolution plan, which I was referring already. Here. Yes. Disclosure process, determination of transaction of whatever avoidance transaction, the responsibility of RP, and submission of complaint resolution plan to CoC, then RP, then evaluation, then CO. This is the responsibility of CoC, evaluation, and strictly whatever as per information memorandum, he has to CoC has to see that they are approving the plan, and submission of resolution plan approved by CoC to AA with compliance certificate in. This is again the responsibility of RP. Continuing to manage the operation CD in order under section 31, again responsibility of RP. Then again the AA order, preservation of record, all this is again responsibility of RP. Application to AA for extension of period. This is very important. Here with approval of CoC only, with the 66% approval only, he can go for extension of period. With the 66% only he can go. Then to abide code of conduct and disclosure of pecuniary and other. It's a very important thing. Now, if you see in many, these are the things what section 25 where you can see, here it only 28 gives responsibility both CoC and RP to see that they both are together. Of course, the RP under the instruction of CoC under section 28, he has to see that these things they are executing. These are the things that the RP is executing. Otherwise, most of the responsibility is for RP only. Of course, few things on the 50% approval and few things on the 66% approval. Here, one of the important case law, even the IBBA has referred here. Very interesting to note here. See, in the matter of which in the beginning of session also, I was referring this particular judgment case, see there with us IOB, the Honorable Supreme Court, that it very clearly held. The legislature has not endowed the NCLT with the jurisdiction or authority to analyze, evaluate the commercial decision of the, that's what we are talking about, commercial wisdom, commercial decision of CoC, much less to inquire into the justness of the rejection of the resolution plan by dissenting financial creditor. So it further, Supreme Court has observed, besides this commercial wisdom of CoC has given the paramount status without any judicial intervention for ensuring completion of stated process within timeline prescribed by. So that means the timeline also has to be followed. Therefore, Honorable Supreme Court wanted the lower court not interfere into the commercial wisdom of CoC. And of course, recently, if you see one of the case where I could come across, where the Supreme Court has clearly said, one of the matter, I read the recently one case law I read, where little different to this. I wanted to show that, no, I can't show this, but at least I can read. One of the matter in Vallal Rig RCK, Shiva Industry Matters. Shiva Industry Matters is the respondent, and it's a Supreme Court, again a civil apply 18, civil appeal 181118 12 of 2022. In that judgment, they made very clearly that it's very important judgment. Again, one has to understand that NCLT or adjudicating authority can interfere in Shiva in the holding industry. I'm saying the recent judgment in 22 that wherein it says the Supreme Court has said the NCLT can interfere if settlement plan is capricious, arbitrary, irrational, and de-horse law. So this very important judgment which recently, I have come across, whereby it's 1811 of 2022. I think I will share the copy also along with my PPT, this judgment. So wherein the Supreme Court has again said, but little the stand is getting little change, whereby the Supreme Court has said adjudicating authority or honorable NCLAT can interfere if the settlement plan is arbitrary, irrational, or de-horse of law. Means if it is little not falling in the law, then they can interfere, even if it is the commercial wisdom of CoC. This is again important exceptional. Now we are getting out of the Supreme Court, which has been observed in case Sadhidhar versus IOB in the judgment dated 2019. So this is a judgment much after the Sasidhar judgment, 5th February 2019. This judgment is it's a recent one. I told you the number. I'll share the judgment copy also, where the Supreme Court went on to say that the NCLT can interfere on these reasons, only on that 4 reasons, where it feels the adjudicating authority honorable NCLAT feels that the plan is not in line or arbitrary or irrational ideas of law, but it goes beyond the ambit of law. So then they can interfere. So that means commercial wisdom is not completely full at free of cost. And it is the Supreme Court, Honorable Supreme Court has observed that commercial wisdom is not simply given in the hands to the CoC and without intervention of NCLT and NCLAT, but NCLT or NCLAT can interfere provided these elements are present. So that means this falls as an exception to the earlier judgment of Honorable Supreme Court, the recent judgment of the Supreme Court. That's why I showed this particular provision. So there's again little exception is given by Honorable Supreme Court in this particular matter. Now going back to the PPT now, I wanted to share certain important points here. This is a thing which we were discussing about 66% voting share. Here again, the submission of resolution plan, again we need RP has to see that he is presenting the plan and CoC may approve the plan by vote and not less than 66% of voting rights as per section 30. Now coming to the regulation. Regulation 8, if you see claims by financial creditor, we are all the following, while collating the claim, we are all sticking on to this because for want of time, I'm these are the regulation which we go through while collating the claim and verifying the claim. Okay. Here the author is representative, so select the IP and which we are discussing just a while. I wanted to show you certain important points on that I take you. These are the content of the notice, which I can share. Yeah. So constitution of committee meeting and service of notice. It has to be sent electronically by means sent to the participant through email, text. Of course, I will share the PPT. You can go through this. subject line email shall state name of the corporate data. These are routine regulation 20, which states should be the notice sent in the form of non-editable attachment. That's more important. Should not be editable one. So that attachment shall be in the portable document format and non-editable format together with link and instruction. When notification will send by email, the RP shall ensure it uses a system that produces confirmation of the total number of recipients. These are the things that we should make sure that the RP who are endeavoring to do the serving of notice to the CoC members. They have to see that all these parameters are followed to stakeholders wherever they are serving the notice, and the content of the notice. They inform the venue, time, date, and period option available. All that. The notice of meeting shall provide the participant may attend the meeting, either in person or office. This particular language has to be, information has to be provided. Then content of the notice, then again shall inform the department shall inform RP in advance of the meeting the identity of the AR, whoever will attend the voting. All that needs to be given. The detail has to be given to RP by the person who are AR. Notice of meeting, say the process of manner of voting by electronic means and provide login ID. All that's become part of the thing. Then quorum of the meeting, which we are discussing, at least 33% voting rate at present, either in person or by video conferencing. Here the committee may modify the percentage. So suddenly we have seen in the table where the committee may modify the percentage of voting required for the quorum in any future meeting. If it is not held for want of quorum, committee previously decided otherwise, the meeting shall automatically stand adjourned unless the committee decide before the meeting. Participation through video conferencing also, another important aspects which the notice convening the meeting shall provide participants an option to attend the meeting through video conferencing or other video visual means in accordance with the regulation. The resolution professional shall make necessary arrangement to ensure RP shall take due reasonable responsibility and care. The participation through video conference, these are the things that he has to see, make sure that he is taking a due care to safeguard integrity of the meeting and availability of proper video conferencing to record proceeding, prepare minutes and store safekeeping the physical records, and other than the intended participants should attend or access to the proceeding. These are the important things that the RP should make sure while conducting the meeting through video conferencing. Participation through video conferencing. The meeting is conducted whenever through video conferencing. The schedule venue as set out in the meeting shall be in India. It will be deemed as a place of the meeting date. These are the RP shall act as a chairperson of the meeting of the committee. And RP shall take the roll call, and all this is routine thing the RP has to do in every meeting. Every person attending through video call shall state for the following, and he has to record the following: name, whether he is attending in the capacity of CoC member or participant, whether he is representing member of group of members, location, whether he has received agenda, and no one has access. All that he has to say. After the roll call, the RP shall inform participant name of the person. So all this is a routine process that the RP has to follow while conducting. Then after that, the decision shall ensure the minutes are made in relation to each meeting of the committee and shall disclose to attend the meeting in person. And the associate person shall circulate the meeting to all participants by means of electronic by within 48 hours of said meeting. So again, now coming to the voting, we have seen the list of item. Okay, section 28, what it says. So regulation 25 of CRP, it says that the action listed in 28 should be considered in the meeting of the committee, and it requires approval may be considered in the meeting of the committee. Any action other than RP shall take a vote of a meeting of committee in present the meeting or any item for that. Conclusion of vote at the meeting, the RP shall announce the decision along with the names of the members who voted for or voted against. RP shall circulate the minutes by electronic to all members of committee within 48 hours, which I said, and seek a vote of the members who did not vote at the meeting on matter listed by electronic voting, which shall vote, kept the voting all the circulation of minutes, and for such time as may be decided by a committee, but shall not be less than 24 hours, shall not exceed 7 days. Provided the extension may be given, voting window shall be extended for an increment. So all this has to be deliberated by RP with the CoC, and they have to take a decision on this. At the end of the voting period shall be blocked. Then after the conclusion of vote, the RP shall announce and make a written record of the summary of decision taken on the relevant agenda, along with the members of the committee who voted for against the decision. RP shall circulate a copy of the record and to all participants by electronic within 24 hours of the conclusion. Here the cost of the IRP, if you see that here importantly, the amount of the expenses ratified, that is very important here. So the applicant shall bear the expenses which shall be reimbursed by the committee to the extent it ratifies. Okay, the amount of ratified. So resolution professional cost, the committee shall fix the expenses to be incurred. Okay, it's not that simply you can do. What are the expenses? What are the things are included? Items are included. It includes the fees to be paid to RP, fees to be paid to NDT, fees to be paid to other professionals. We have seen the professional under regulation 27 who and all RP can appoint. Approval of resolution plans shall submit to the committee of all this is avoidance transaction. If anything is there, the RP, it is a responsibility of the RP to inform and put the CoC on notice the avoidable transaction, if any. Okay, and committee shall evaluate the resolution plan decision on regulation 2 as per evaluation matrix, record its deliberation on the feasibility viability of each resolution plan and vote on all resolution plan simultaneously. Here another important thing, meeting liquidation cost. While approving plan or deciding to liquidate the CD, the committee may make a best estimate of the amount required to meet the liquidation cost in consultation with the RP in the event of order of liquidation cost. So this is another important thing. In case the plan is not approved, if liquidation is suggested by CoC, CoC has to see how much the best estimate required to meet the liquidation cost. Then CoC has to contribute to the RP to meet out the liquidation cost. So this is another important thing where the committee shall make a best estimate as I was telling. Where estimated amount liquidation is less than the estimated liquidation under regulation 1, the committee shall approve a plan providing for contribution of the meeting of difference between the both. The RP shall submit plan to AA while filing the approval or decision of the committee under section 30. So here another important regulation 39C, assessment of sale as going concern. Here another important responsibility given to CoC is that while approving a plan in section 30 or deciding to liquidate, the committee may recommend the liquidator to must first explore sale of corporate data as a going concern. It's very important. Or sale of business of corporate data as a going concern. Plus thereof, if an order of liquidation falls under 33. So after 33, first the liquidator should ensure that the first action is given. That corporate data as a going concern under class E of regulation 32. Or else the sale of business as a corporate data under class F. So where committee recommends sale as a going concern, shall identify group of assets and liability which according to the commercial consideration ought to be sold as a going concern the class C. So this is the another responsibility committee of creditor where they have to see that they are identifying the group of assets and liability which according to the commercial consideration ought to be sold as a going concern. These are the things given in the hands of the commercial decision given in the hands of the CoC. The RP shall submit the recommendation to the committee on regulation to the AA while filing the approval. Again, the fee of liquidator approving the resolution plan designed to liquidate. Committee may, with the consultation of RP, fix the fees to the liquidator. The extension, the committee may instruct the RP to make an application to the AA to extend the insolvency resolution process. So this is again, these are the items which we have seen. Approval 66% is required. Constitution CoC meeting. I want to take the important points. So these are the important points which I thought I should inform to you. The major role and responsibility of CoC. To take the important decision to approach AA if required, to change the resolution approach, to initiate a proceeding, or in case of disassociation resolution fund, to replace the RP. So these are the things important in conducting CoC meeting. what are the important things. These are the things that RP has to be careful and mindful. What are the things they have to give along with the notice and how it should be sent, all that, which I was deliberating earlier in conducting CoC meeting. So he has to make sure that he is following all this. He requesting CoC for physical voting and voting time, keeping the online meeting, the webcam of chairperson must be on, and all other must be kept on mute to ensure the seamless meeting. So all this is the basic parameter he has to follow. Yeah, I'm done with my session. If any doubts, you can ask me. So if any deliberation or any points that you want to discuss, we will discuss, then we will close. Yeah, go to organizer. Any points that we need to deliberate, we'll deliberate and close.
It was a very interesting session, sir. Quite a few points which we had missed were brought out by you. So it was a good learning for us.
Sir, I had a query. Once the resolution plan after approval of CoC is submitted to adjudicating authority, what is the role, rights, and responsibility of CoC?
Once it is approved.
Yes, sir. CoC is approved. It is pending with AA.
That's all. Then what it goes by the plan, whatever the plan provides for. Suppose the RP is appointed as a monitoring, and many of the plan, the RP is appointed as a person who is monitoring person, and he comes out of the role of RP, then it goes as per the plan. Whatever plan provided for, it goes as per plan. And CoC will not have a role unless plan specifically says something, and which has been approved by AA.
So do you have you come across any precedents or judgment where CoC has tried to reopen the plan after approval of CoC when it is pending with
No.
AA?
Recently some recent judgment I could not recollect immediately now. I have come across a judgment recently where after approval of adjudicating authority, CoC should not be permitted. Recently I have seen, somewhere I have seen, could not recollect, but recently I read after approval of AA, CoC is not permitted to reopen.
No, not after. I am talking about between CoC approval and AA approval. In that interim period, can CoC reopen the plan?
Open, then see, then every time if you reopen, every now and then, if you restart the process, then where is the question of 180 days, 270 days timeline you follow?
Yeah, absolutely. I agree.
No. See, if I permit one time, then you are permitted to reopen anytime, any number of time, right? I'm just
yes, it should not be. I've seen in some plan CoC is trying to do it. So I thought to bring it before you.
See, INB, Insolvency Bankruptcy Code, though it has got provision, limited provision, but now with the judgment and orders, now it got enlarged like anything, right? But of course, within the ambit of court, no doubt, because since it is being passed by the court, okay. See, there are only 255 sections in the code, but there are 2,500 scenarios which have been answered by courts. Okay.
Very well, sir. Very well.
Madam, if no more questions, can we close? Madam Asha, are you there?
Yes, sir.
Thank you all.
Thank you, sir, your valuable time and this insightful session.
Thank you all for patiently hearing. And I thought I want to take this opportunity to take your inputs. That's why I
Thank you, sir. Thanks a lot, sir. It was a good session, sir. Thank you.
Thank you.
So there is a break till 2 p.m. Thereafter, we'll continue with the session.
With the
Thank you.
same link, ma'am?
Yes, yes.